Hi, my name is Larry Newman. I'm an attorney in Ithaca, New York. Our practice concentrates on DWI defense. Today I want to talk to you about an interesting DWI case that recently came up on appellate review. It's a federal case. So it was a pilot. So a pilot, just like a truck driver or a bus driver or a captain of a ship, is considered a common carrier because they're responsible for more than one person. They're responsible for all the passengers that are on their plane or on their boat or on their bus. But the level of alcohol in that particular situation is 0.04, not 0.08. So let's start with that. So the judge starts out his review of the case and he says, we have a rip-roaring drunk pilot. Rip-roaring drunk. And I think that I agree with the judge because this was 7 o'clock in the morning, and when they checked the pilot's BAC, blood alcohol content, it was 0.34. Now, 0.34, if you want a reference, that's 8 times 0.04 would be 0.32. So it was more than 8 times the limit for a pilot. It was more than 4 times the limit for a person in a car. But yet he was still functional, so I think he was a functional alcoholic. But this case was interesting because the argument was, after he's found guilty, and the jury found him guilty because they saw there was a common carrier, he showed up drunk, and they considered that he had operated the plane even though the plane had not moved, even though the engines were not turned on, because he did a walk-around inspection, because he checked the altimeter, because he called into air traffic control, because he went through a flight plan, because he did all those pre-things. They considered that operation under the law, under the federal guidelines. And that's the same thing for even a car. Even if the car is not driven, operation is a very wide term, and it includes driving, but it also includes all the things in preparation for driving, like turning the car on or sitting behind the wheel of the car. So we can make some analogies there. But this particular case was interesting because he was arguing that he didn't put the plane in motion, that the plane engines never got turned on. But let's bring some common sense to this picture. If we have a pilot and their job is to ready an airplane for flight, there's a big checklist, a huge checklist of things to do both before, during, and after a plane is already in the air. So we do not want to wait until somebody is already in motion or moving with a large common carrier before we say, hey, listen, you're too drunk to fly or you're too impaired to fly this plane. I think that USA versus Fitzgerald, that's the name of the case, speaks to a bigger thing with DWI cases or even DWI drug cases. There is an element of common sense, an element of common sense that needs to be looked at before we start to bring motions or hearings on any of the elements, because we have to look at, well, what are we really dealing with here, and who do we have behind this, and where could we really argue? Could we really argue that the BAC was wrong because of the blood test? Could we argue that perhaps he wasn't drunk because the blood test was wrong? I think that would have been a better argument because it was so high and he was so functional than the argument that he did not operate the plane. If you have a question about your DWI case, and we also handle cars, is you can give us a call, you can shoot us an email, you can fill out the form on our website. We'd be more than happy to discuss it with you. And thanks for watching this video.